but there are 4 that are involved. They're aged 4, 5, 6, and 7. These children talk more readily about seeing the defendant sexually assault one of their siblings.
Welcome to Bench Report Court Cam.
You're there. All right. Okay, there you go. Sorry to wake you up. No, go ahead.
I apologize.
Good morning, may it please the Honorable Court. James Johnson, going to be asking Mr. Brown as both cases, Your Honor.
And what are we doing today?
Your Honor, we're asking for a preliminary examination on both cases, and I'd like to address my client's bond.
All right. Is all discovery complete?
Yes, sir, Your Honor.
If the people have the witnesses available on the second?
We'll do our best, Your Honor.
Your Honor, the scheduled to be in the East Lansing and Lansing District Courts on the 2nd. Is it possible I can have a different day?
Yes. You could have the 7th.
9 a.m.?
Will that work? The 7th?
Yes, Your Honor.
Okay.
The matters I have on the 7th not going to go.
Would the people have their witnesses available the 7th?
Continue to do our best. Thank you.
All right. Preliminary examination in person will be set January 7th, 2025, 9 a.m. That is before Judge Perry in both cases. Okay, yes, and that's the bond.
Your Honor, currently as to both cases, my client does not have a bond. We're asking the court for a $30,000 cash assurity, 10% bond as to both cases. My client is not a flight risk. He does not have a passport, does not have a car, he does not drive. He is joined in the courtroom by friends of the family and family, which includes his mother and sister. We do not believe that he is a danger to the community at large. He has no prior criminal history that I'm aware of. We do acknowledge that the charges are serious. The court can address that through bond conditions. There are no minors or minor children that he needs to be around. He can go to his mother's home and not be around any minor children. He has numerous people that make sure he gets to and from court. I've been in constant contact with his mother, his sister, and family members who are all here to support them. They even brought letters in case I needed to do a more formal bond motion. So we'd ask the court to consider allowing him to do post a $30,000 cash surety bond as to both cases.
Response.
Sir, it's my understanding that bond has been denied.
Yes.
Yes, and Your Honor, I would request that the court continue that stance. Obviously, MCR 6.106, that's allowable. Judge, it's my best understanding, although I did not write the warrants in this case, that this pertains to sexual abuse of 2 are charged, 2 minors, but there are 4 that are involved. They're aged 4, 5, 6, and 7. They have all been interviewed. They all give various accounts of this defendant assaulting truly all various ones of those children.
Let me make sure I understand what you're saying.
I'm not saying
there are 4 children that are involved.
Yes.
But as of this point, only 2 of the, whatever the incidents are regarding, only 2 of the children have been charged.
2 are charged victims. That's correct.
Got it.
There is information from their interviews that lead me to believe that after a preliminary exam, it feels likely that there would be additional charges involving the same children already listed and quite possibly the 2 other children. These children talk more readily about seeing the defendant assault one of their siblings rather than themselves.
Understood. Okay.
So, Judge, I would not be surprised if there were additional charges following a preliminary exam. I would indicate to the court that something that has not been charged but was disclosed in one of the interviews involved gun at the children and threatening them. Obviously, counsel's correct. He's facing significant prison time. These are 25-year bandits. And when and if additional charges are levied, if they also involve additional CSC first, those would be discretionary consecutive, as obviously the courts are aware. So we're talking significant exposure here. We're talking a year's worth of assault on young children. I would ask the court to maintain its current bond ruling, which is to be denied, just for the safety of the community.
Anything else, Scott?
Your Honor, there was extensive investigation here. No firearm was ever recovered from my client. The court will take the credibility of the children and inconsistent statements at the preliminary examination. However, again, all this can be addressed through no contact orders, house arrest, tether. He is not a flight risk. He is presumed to be innocent. And at this time, we do believe that the court has to find under that court rule that he is either a flight risk or through clear and convincing evidence, he's a danger to the community. I do not believe that there is clear and convincing evidence that he's a danger to the community with bond conditions that would include no contact orders with anyone the court may deem vulnerable at this point, Your Honor. So we'd ask the court to set the monetary bond with protectionary bond provisions, Your Honor.
The court does believe, and the court has reviewed the bond form that was filed by the people, that the court would consider the defendant to be a danger to the community as well, these children as well as any others. And while the court could certainly issue that condition, given the circumstances as the court understands them, that would not prohibit the defendant. I mean, it would be sort of an after fact that if we were to get there, and I don't think that that risk should be taken. I think that the magistrate followed the statute in regarding denying the bond. The court doesn't see a reason to change that. Motion for bond reduction is denied. Bond will continue as denied. Thank you.
Thank you, Your Honor.
Court does call the case People versus Melvin Langston. We have another one, Counsel?
Yes, sir, Your Honor. But
Well, it's going to come up whenever it comes up.
Okay.
I can't. With that one.
Thanks for watching. Stick around longer and click the highlighted videos to your right. See you there.